Looks like we're good to go. All right, so it's a pleasure to be here, and the picture on the front here has almost nothing to do with the presentation. It's just a way to get your attention. This is a Federal Express cargo jet that is apparently engaged in military-like maneuvers. We'll hear a little bit more about that later. So just a little bit of background about how I got to where I am and actually being here at this conference. My background originally was in accounting, and I got bored with accounting and I studied law. And then I wanted to somehow put law and accounting together in a meaningful way. And one day in 2013, I stumbled in the university library across a book by Sharon Birch McGrain. Some of you may have seen this book. I'm just curious, how many of you have read Sharon's book? It's up on the screen here, just by show of hands. So not very many of you have. It's a great book on Bayesian reasoning and the many ways that it's applied. Anyway, I read her book and it just lit a fire in me. I had to know more. And so I went looking for a Bayesian statistician at Kennesaw State University, where I was then teaching, and there was only one on the faculty who claimed to be a Bayesian. Everybody else was too embarrassed to say it if they were. And so his name was Brad Barney, and Brad led me down a path that a couple of years later resulted in my starting a Master of Statistics, a Master of Science in Applied Statistics, which I completed in 2016. And kind of as all that was happening, I started hearing these little rumblings about Bayesian networks, and at some point stumbled across the GINA risk that some of you may be familiar with, as well as Bayesian Lab. So I built a little Bayesian Lab model to model the probability of my actually being here to present today. And you can see that even with entering some helpful evidence there, it still is very unlikely that I should be here at all. So it's a pleasure. I'm glad I am, but it's unlikely. So about these pictures. The picture of the FedEx jet actually is a simulation of an actual event that happened in 1994. Some of you may have heard the story. If you want to know more about it, I'll just refer you to this little link down here, Wikipedia, and also you can see that there's a YouTube video. And a very crazy story, but it doesn't have anything to do with our event here. FedEx does have something to do with it, and it's the FedEx Case. Actually, it's a case that another airline called ATA filed against FedEx back in 2008. FedEx had a team of airlines. They called it part of the Civil Reserve Air Fleet for the military, U.S. military. And ATA was capturing about 50% of the revenues of that team that FedEx had organized of airlines. Well, FedEx decided that it was no longer profitable for them to have ATA involved, and so they dropped ATA from the contract, from the team, about halfway through 2008. And that resulted in ATA declaring bankruptcy and then filing a lawsuit for breach of contract and some other kinds of claims. But as part of the breach of contract claim, they alleged that they had lost profits. So this is a typical path or a typical framework in which companies will demand payment. They'll file a claim for lost profits. And so we call this area of the law economic damages. And there are a couple of approaches to measuring damages. One is temporary impairment. Another is permanent impairment. So where the company appears to be permanently impaired, then we'll use a loss of value model to go about measuring damages. So we'll just compare value before and after the triggering event, the breach. The other model is the lost profits model, and we just look at either before and after or some kind of a benchmark. In this case, ATA, the plaintiff in the case, went with the before and after model. And you have to have a little bit of history there, or the courts won't countenance, they won't listen to your complaint. They did have a little bit of history. And the basic idea is that you look at whatever the lost revenue is, and you subtract from that any avoided costs. So costs that you have avoided because the contract was breached. So this is the revenue lost through the breach, and this is costs that are avoided because of the breach. And the net of those two will be your lost profits, right? So that's the basic model. So in this case, there was actually surprisingly very little data that the expert for ATA had to use. And what typically happens is the plaintiff and the defendant will both field experts who will produce some kind of an estimate of the damages. A lot of times, though, the defendant will not estimate damages at all because they think that psychologically it's better for them to just let the plaintiff kind of hang their model out there and then critique it instead of providing their own model. Right? Anyway, so the data that were available were 10 years worth of actual revenue and actual costs associated with this military contract. And so here's the tabular approach, and then this is just a little line chart here that shows the relationship between the actual revenues in blue and the actual costs in orange. So you can see that here at the tail end of the 10-year period, there's a pretty big separation between the two, whereas before it's tracking pretty closely, right? So anyway, we have a scarce data problem. We're also missing contract revenues and costs for 2008. And since the lawsuit was filed in 2008, that's all that really mattered to the calculation. There were no present value calculations or anything like that involved because it was all just happening so quickly. But they needed contract revenues, which they couldn't get because they were dropped from the team. And they also needed costs. So FedEx expert thought, well, I've got better information about contract revenues because there's several sources that I could look to for some benchmark or indicator of what revenue would be. I don't have anything on 2008 costs, and so what I'll do is I will use linear regression to estimate the costs. I will model the costs based on the single predictor of revenue. And just looking at this little line chart, the uninitiated will look at that and say, oh, that looks like it's a pretty fair predictor. There's a little bit of separation there, but let's go with it. So that's what this expert did. Now, if you look at this little chart, this is a representation of the basic workflow in a linear regression project. And those of you who are familiar with linear regression, you'll know how many ways a linear regression can go wrong, right? I mean, there are just all kinds of problems with linear regression. One of them is just looking at the basic workflow. Think about the information entropy that is implicit in all of the different states that could arise from following this kind of a model. Lots could go wrong, and it did in this case. So ATA, that's the plaintiff in this case, the small airline that was dropped from the contract, their expert went ahead and did a little linear regression, regressing costs on revenues. And these were the coefficient estimates that they came up with, that he came up with. Now, he did not use R or any other statistical package. He just used Excel, just basic Excel linear regression. And he came up with the same estimates here, but Excel just doesn't have the sophistication in terms of residual analysis and all kinds of other things that some of these other tools have. So in any event, you can see here are the estimates. Here's the p-value for the revenue variable predictor, and then here's the adjusted R squared for the model. Right? With this information, then the expert went ahead to build a little Excel spreadsheet in which he input this forecast revenue. Forecast revenue was the transport team's actual 2008 international contract revenue of about $609,000 times the expert's ballpark swag, I'm going to call it, of the plaintiff's historical 47% share of that team revenue. So that's how this number comes to be. So we got the revenue, we applied this coefficient to it to get the cost. We've got our intercept here, and so this leads to a forecast of avoided costs, all based on linear regression and this estimate of the revenue, right? So avoided costs, this is the revenue minus the avoided costs, and this is the forecast net profit. We added in a little bit of interest on the revenue, and some depreciation that was not a cash cost. And this gets us to a figure called lost EBITDA, which is earnings before interest, taxes, depreciation, and amortization. It's an accounting thing. And we multiply this times 18/12 to get 18 months worth of lost profits. And that's the number they came up with. Right? Sound good? Notice that it's all deterministic. Every one of these things is a point estimate. There's no treatment of uncertainty, confidence intervals, nothing like that. Right? Okay. So here was the expert's testimony. He later was criticized for his assumption that revenues could be a predictor of costs and not the other way around. We'll get into that a little bit more later. But this is what he said on the stand at the trial. So the number of miles the planes fly, the destinations the planes fly to, the number of seats, the type of aircraft, that all affects revenue. Revenue is what in the airline industry is what drives the cost. So as the revenues change in an airline for inputs, as revenues change, your costs are going to change. The input here in this particular case are going to be plane seats, costs of filling the seats, costs of training the pilots, costs of training the flight attendants and the crew, etc. So as the revenues change, those costs associated with it are going to change. So that's his basic philosophy, is that revenues are the driver, they're the predictor of costs. And that there is a causal relationship. He's very clearly stating that there, right? So now experts, when they're testifying, they begin by delivering to the court and to the counterparty or the other party, opposing party, they'll deliver a report that details everything that they are going to say at trial. And so what we have here are excerpts from his report and then a little bit more from his trial testimony. So in his report, he said, the p-value explains how much of the data is explained by chance rather than by the relationship of the variables, which means in this case that greater than 99% of the data is explained by the relationship of total cost to total revenue. Now, if you know anything about p-values, you'll know that that's just a totally incorrect statement of the meaning of the p-value, but that's what he said to the jury. I'm sorry, that's what he put in his report. So to the jury, which the jury did not see his report, they just heard his testimony and saw his exhibits. So at trial, he said, my R-squared was 0.956, so my significance test is based upon economically plausible variables was a 95, or 0.95. I don't know about you, but I have no idea what that means. But the jury bought it. He also said here, p-value is the percentage of variation in the target explained by the variation in predictors. Now, that sounds more like R squared. Not quite, but pretty close. So that was his report and testimony. Now, typically when you do a linear regression, you are also, if you're using it to estimate some state, like lost profits, then you would also deal with confidence intervals. And you'd also want to take a look at your residual analysis that results from your linear regression. This expert didn't do either one of those. And that's why it's showing this crickets thing here. And there should be a little bit of sound that goes with this. It'll take me to a YouTube video if I'm really hooked up to the internet. Come on. Yeah. So you get the feel, right? That's probably enough of that. Okay, so. All right, so we go next to residual analysis. And if you do just one little piece of residual analysis looking at plotting residuals against fitted values, you see this kind of a fan pattern. And that's a clear sign of non-constant variance, and it violates what we call the E part of the line assumptions that are required for a good linear regression. Now, the reason I'm pointing this out is that this is an expert who's been paid over $2 million to provide this testimony, and there are major pieces of this linear regression workflow that he just didn't address, or at least he didn't put it in his report or in his testimony. And that raises some questions about the basic idea of using this kind of model. So FedEx also hired an expert, and we call these experts rebuttal experts. They try to rebut the plaintiff's expert. So the FedEx rebuttal expert objected in his report, but he was not allowed to testify. The defendant FedEx didn't want him to testify. But his report said that the plaintiff's regression-based estimate of avoided costs treated revenue as causing cost instead of the reverse. So this is another expert who is supposed to know what he's talking about, and I think for the most part he did, but we have to ask, is there really a causal relationship implied by linear regression? And I think those of us who have read Pearl's Book of Why will pretty emphatically answer that question, no, right? So he also said that the model omitted essential variables and it implied a forecast cost interval that covered estimated revenue, meaning that ATA's lost profits might equal zero. So on CIs, the rebuttal expert said, one could be 95% sure that the true 2008 cost lies within the 95% forecast interval. And so he did not either mention residual analysis of the model, but he rejected the model because of these critiques. So that's where we are. These two experts are battling over this regression model. Now here's a little sidebar about confidence intervals. Now there's an academic, Richard Morey, who has produced a really nifty website treatment of confidence intervals, and he's basically thoroughly debunked them, that they don't do what people think they do. And they haven't ever done what people think they do from the very beginning, from when they were designed by Jerzy Neyman in like the 1930s. So his points, Morey's points, are that a confidence interval does not identify an interval in which the true value can be found with X% confidence, number one. Number two, the width of a confidence interval does not indicate the precision of the estimated value. And number three, values outside the CI are no less likely to be true than those inside the CI. So if that's the case, why use CIs at all? What's the point, right? So he has a great little, as I mentioned, a website out there. This is just one of the graphics from it. He uses a lost submarine metaphor to illustrate, using simulations, the outcomes or the outcomes of these different approaches to confidence intervals. And his bottom line conclusion is, down here at the bottom line, only the Bayesian credible interval has the properties typically ascribed to confidence intervals. So, something to think about. So the jury, anyway, they listened to the plaintiff's expert, and there was nothing coming from the defense because they didn't put on an expert. Nobody testified as an expert for the defense. And so all the jury had was the estimate provided by the plaintiff, which totaled about $66 million. You can see the components here. Up here, this is the actual jury verdict form. They were asked, has ATA proven by a preponderance of the evidence that FedEx's breach was the cause of ATA's damages? Yes. What, if any, lost profits do you award ATA for fiscal year 2008? This much. What, if any, do you award for fiscal year 2009? And so you sum these two, and it's about $66 million, and that is exactly what ATA's expert calculated, what they asked for, right? So now the plaintiff is feeling pretty good at this point. $66 million, that'll help us with our bankruptcy anyway. And then came the counterattack. The case was appealed to the 7th Circuit, which is in Chicago. Anybody from Chicago here? No Chicago peeps? No? Shoot. Wonder why. Chicago is such a big town. You would think there'd be somebody doing Bayesian stuff in Chicago, right? Well, anyway, so Judge Posner, one of the most sophisticated, bright, intelligent, and also egotistical judges in the country. He's retired since he issued this opinion. But on appeal, they're at oral argument, we call it. So there's this process where the attorneys from the two parties show up in front of a panel of judges. There are usually 3 judges that are sitting on the panel. And the plaintiff was just unlucky enough to get one of the panel members as this guy here, Richard Posner. So Posner consumed 11 minutes of about a half an hour set. Well, it was about an hour, I guess. 11 minutes of an hour, just ripping apart the regression analysis, just totally nuking it, in his mind at least. And his big question was, how can revenues drive costs? What is the significance of this regression? I don't understand. You didn't have to use regression. This regression doesn't do anything. Those were his words. Now, if you want to actually hear him say the words, you can click on this little link here, but we won't do that for the moment. What Posner wanted and needed in this case was the ability to deal with counterfactuals, that is, before and after. You know, the ATA didn't end up in the contract in 2008 or 2009, but we want to know counterfactually, what if they had been in the contract? What kind of profits would they have earned? And if you've read the Book of Why, you'll be familiar with this little graphic. Unfortunately, linear regression doesn't get us the counterfactual analysis because it's way down here in the association, at the association level of the ladder of causation, where we need to be up here at the third level in order to do counterfactuals. So, in his written opinion, Judge Posner wrote, ATA's regression has as many bloody wounds as Julius Caesar when he was stabbed 23 times. The examination and cross-examination of ATA's expert were perfunctory and must have struck most of the jurors as gibberish. Even ATA's lawyer on appeal did not understand the expert's analysis. He could not answer our questions about it, but could only refer us to the expert's testimony. Same thing with FedEx's lawyer. Because neither expert nor the lawyers nor the judge presented an intelligible damages analysis, the jury simply awarded the exact amount asked by ATA. So, where am I with time? How much time have I got here?
Yeah, until 11:35, 11:40.
All right. Okay. Still got a little time. All right. So, what ATA's expert really had in mind was this kind of causal Bayesian network when he was saying, all that about all the inputs and the fact that revenues drive costs in the business. What he was really saying is these companies, when they're deciding what to invest and how to get geared up to carry passengers, they start with a revenue expectation. And that revenue expectation then drives an expectation of revenue passenger miles, which then drives both the costs and the revenue. That revenue passenger miles sits there as kind of a confounder between these two, or a joint parent, and that these things together then drive lost profits. So this is actually a causal model that has been blessed by some of the big associations that are made up of these experts. And it's also been blessed by different courts. So apparently there's a difference of opinion between Posner and some of the other courts around. But this is a valid model. It's just that this one court, this one judge didn't buy it. So we could also think of it this way. This was a cost plus contract. The FedEx team's contract formula was basically revenue equals cost times 1.11. So that was their deal with the government. Now you can just shift these numbers around very easily using simple algebra to get cost equals revenue divided by 1.11, right? Why was that not considered by somebody in all this argument about causation? The equal sign has no causal meaning, as our friend here will attest. So, Robert M. Lloyd is an expert who's done a lot of testifying, and he's done a lot of writing on this topic. He wrote an article, The Reasonable Certainty Requirement in Lost Profits Litigation, and he said, in an ideal world, a court would be able to hear the evidence, estimate the plaintiff's damages, and quantify its own confidence that the estimate was accurate. Doesn't that sound like something they could do with Bayesian networks? You could have experts build the model, validate the model through argument or negotiation between the parties, and then just hand the model to the jury or the judge and say, go for it, play with it, come up with your own feel for what the input should be, and then you'll get a much better result. So that's the ideal world. In our actual world here in the United States, we have a lot of case law diversity, I'm going to call it. And this is because every state has its own peculiar approach to this problem. And we also have multiple layers of courts. So we have 3 layers of federal courts, usually 2 or 3 layers of state courts, and they're all talking about this issue. Right? There's a lot of traffic out there about this. So you get things like this little table here, which deals with the relevance, the fundamental relevance of evidence in the courtroom. In order to get any kind of evidence, whether it is a Bayesian network or a linear regression or just a simple Excel spreadsheet, to get that in front of the jury, the first thing you have to do is convince the court that it is relevant. And so these are very similar, actually, definitions of relevance. At the federal level, this is Federal Rules of Evidence 401. Texas and Utah have almost identical wordings. And then we have New York, Georgia, North Carolina, and Louisiana that all read almost exactly like this. And then, as usual, California has to be a little bit of an outlier, right? So they changed it up a little bit. But the basic idea is here, evidence having any tendency to make the existence of any fact of consequence to the determination of the proceeding more probable or less probable than it would be without the evidence. So that's the definition of relevant evidence. So think about that in relation to Bayesian networks. How could we define, how could we quantify whether a piece of evidence makes a fact more or less probable? We just enter it into our Bayesian network, right? And we calculate the likelihood ratio. And the likelihood ratio tells us if the likelihood ratio is equal to 1, then there's no impact of the evidence on the probability. If the likelihood ratio is different than 1, either greater or lesser, then we have relevant evidence. The question is, how much impact it should have. But once it is relevant, once it's been admitted, it's up to the jury or the judge to decide how much weight to give to it. And likelihood ratios could help there as well, but they don't need to be, don't need to help. So here's a little visualization of the number of cases in which the terms lost profits and reasonable certainty appear in one of the popular databases for lawyers. This one is available to all members of the Georgia State Bar, of which I'm a member. And so I ran the little search, and every circle here denotes a single case. The bigger circles are cases that have been cited by other cases more frequently. The orange circles are cases that have turned out to be bad law. That is, some subsequent case has ruled that the conclusion in that case was wrong, right? And so we've got 4,870 cases that came up using these terms. That's at federal and state levels here in the United States. Now, if typically about somewhere between 2% and 5% of cases that are filed with the court originally, that's when a complaint is filed, 2 to 5% of those actually get resolved through a jury verdict. It actually goes all the way to trial. So 2 to 5%. Of all of the controversies that happen that involve estimation of damages, there might be 5% of those that are filed as complaints to begin with. So think about the magnitude of the market out there for disputes over damage estimates, over economic damages. There are thousands, hundreds of thousands of cases that have been filed over the past, since 1960, we'll say, and there are probably millions of disputes that haven't been filed. So it's a huge market out there. All right, so let's take a look at a few notable quotes here. Justice Oliver Wendell Holmes. Has anybody ever heard of Oliver Wendell Holmes before? Yeah, one or two of you. He's one of the most famous judges of all time. He was a Supreme Court justice and said all kinds of important things, and people still talk highly of him. So in this case, Ithaca Trust Company versus United States, back in 1929, he says, the first impression is that it is absurd to resort to statistical probabilities when you know the fact. He must not have been a statistician if he thought that he could actually know the fact. Because nothing is ever certain, right? Everything is probabilistic. But then he goes on to say, but this is due to inaccurate thinking. Like all values, as the word is used by the law, this value, in this case that he's talking about, depends largely on more or less uncertain prophecies about the future. If that isn't what Bayesian Lab is all about, is making uncertain prophecies, I'm not sure what is. So here's a law student. They write these things called notes. No, I'm sorry, this isn't a law student. We'll get to one of those in a minute. This is another judge. This one is a judge with the Supreme Court of Oregon, and this is in 1977. So this is 50 years after Judge Oliver Wendell Holmes. And so Judge Lent says, I have no more idea what reasonable certainty means than I have as to the meaning of certainty. I would assume that it is some lesser quantum of proof than beyond a reasonable doubt or to a moral certainty. And then here is a little bit more detail from the Second Circuit Court of Appeals. This is a federal court, appellate court that sits in New York City. And so they're hearing a state law-based case, and so they're going to use New York law. And they say, in New York, a party is entitled to recover lost profits as consequential damages only if it is demonstrated with certainty that the damages have been caused by the breach, the extent of the loss is capable of proof with reasonable certainty, and it is established that the damages were fairly within the contemplation of the parties. So this is where there are like collateral contractual relationships that are dependent on the outcome of a particular dependent on the outcome of the contract that is at issue in the case. So if you want to get more direct, you go to general damages. When the non-breaching party seeks only to recover money that the breaching party agreed to pay under the contract, the damages sought are general damages. These lost profits are the direct and probable consequence of the breach. So there's judges have a really hard time dealing with this uncertainty stuff, and you can see them struggling here. And they're very sincere about it, but it still leaves you kind of wondering, what does this all mean? So we can look at this second paragraph. Certainty as it pertains to general damages refers to the fact of damage, not the amount. The burden of uncertainty as the amount of damage is upon the wrongdoer. The plaintiff need only show a stable foundation for a reasonable estimate of the damage incurred as a result of the breach. Such an estimate necessarily requires some improvisation, and the party who has caused the loss may not insist on theoretical perfection. So yet another judge, this one is with the Federal Court of Claims, and this is more recently in 2004, says, does determining the amount of lost profits here involve some degree of speculation? Undeniably, but only because the apparent dichotomy between reasonable approximations and speculation is misleading and demonstrably false. As Justice Black once observed, damages are bound to be speculative and conjectural to some extent. So when does one pass from the realm of permissible speculation and projections to that of intolerable guesswork and largesse? The answer, of course, depends upon the record of a case, but the overarching objective is to ascertain whether the approximations and assumptions used to set the amount of damages are anchored to the facts, consistent with sound economic theory, and ultimately will produce reasonable results. So y'all have a clear picture now what reasonable certainty means and what's required? I don't. I still don't. Right? It's still not really super clear. So there's what's called the fact and the amount rule. This is the note from the student who says, it appears that the fact of the loss and the amount of the loss are in effect different terms for the same thing, since proof of the amount of loss with a reasonable degree of certainty conclusively establishes the fact. And conversely, the only way to prove the fact would seem to be proving with reasonable certainty at least a minimum amount. That sounds pretty good. It's better than the judges. Right? So ATA, they did their regression, and then several years later, of course, with all of the benefit that hindsight conveys, I came back and I redid it all. And one of the things I did was I used R to do what's called an all subsets regression. Has anybody done all subsets regression here? How many of you have done that kind of thing? I'm just kind of curious where everybody is in terms of their regression. You've done all subsets? Okay. So it's just basically you're going through, and the machine, it's looking for all the possible models that would result from a collection of variables. And so I identified one that had really good adjusted R-squared, a good Mallows CP, and a good AIC. These are all metrics that are supposed to indicate good fit, right, of the model. And so it was a different one than the FedEx's expert used. And I decided, well, let me just put this into a Bayesian network. And I used Agena Risk instead of Bayesian Lab. I'm still working on putting this into Bayesian Lab. I'm not nearly as good at Bayesian Lab as I am at Agena Risk yet, but I'm getting there. And Lionel is going to help me starting on Monday to get even better, right? Yeah. So anyway, this was my Bayesian network model, and I'll just walk you through it really briefly here. So one of the most important things here is the projected revenue for the whole team, because ATA should be entitled to a percentage of that, right? So we can use different statistical distributions to model these things. For most of these numbers, I just chose what Agena Risk calls a truncated normal distribution. So it just cuts off those really long tails, the forever tails that you have in normal distributions. And then for a couple of them, I used now I can't remember the name of it's a beta distribution, right? Because it just seemed to me that the shape was more consistent with what I would expect of the variable. So we had 4 different sources of revenue estimates. One was the FedEx team's actual 2008 revenue. This is including the 6 months that ATA was on the team, and then the rest of the time when they were not. So that would be a possibility. Another one was ATA's first 6 months of 2008 times 2, right? Another one was ATA's pre-breach 2008 budget. So this is where they were looking ahead in time, looking in the crystal ball before they knew they were going to be dropped from the contract. And they said, well, this is what we think the team will earn. And so all these numbers are team revenue numbers, of which ATA is supposed to get a share. Well, so these 4 nodes here are all collected and weighted, just a simple weighted average kind of a thing here. And then we apply the plaintiff's share of team revenue, and we didn't really know for sure what their share was going to be. It varied from year to year, and so we made 47% kind of the middle of the distribution, and that led to plaintiff's lost revenue being modeled this way. And then we've got plaintiff's avoided costs, of which revenue was a major input. And then we had these coefficients from the linear regression model that I built using R. So I put these 2 things together to get these 2 things and the interest and depreciation that we modeled over here to get our 18 months of EBITDA. So these are the marginal probabilities before entry of any evidence. And then if we enter a couple pieces of evidence, then we get this kind of thing here. And so it would be a relatively easy thing to provide this kind of a model to a jury. It's also really easy to show them. You can stand there in front of the screen. Now, I can't because I'm told I have to stand in between these 2 lines. But if I were in the courtroom, I would walk up to the screen and I could point to these different boxes and I could explain the logic behind each one. And the jury would have a graphical, a visual understanding of how these things work together and what the dependencies are among them, instead of just this flat little regression formula thing, right? So, all right. So you can also do the same kind of thing in Bayesian Lab, but this is a tornado graph that shows, which factors are the most important. This could be very helpful to a jury in determining which variables they should spend the most time analyzing. Also could be helpful for the parties because they can focus their attention on fighting about those instead of fighting about, the big ones are the ones that have the wide bar here in the tornado graph. These are most important, and these ones down here aren't so much. So the avoided costs are huge, right? So that's going to be should be a big point of contention. So it's a great way to focus the conversation. Okay, so let's talk about some of my interpretation of why Bayesian networks would be a good thing in the courtroom. And so first, they transparently present variables, dependencies, whether they're causal or not, and probability distributions over the sample space. So we deal with uncertainty. We eliminate zero probability point estimates and bogus confidence intervals. We've got real confidence intervals that actually do what they're supposed to do. We facilitate model exploration, validation, and sensitivity analysis by fact finders. That's like judges and juries, encouraging buy-in, their ownership in the outcome or in the output, and also corrective feedback on the model. Now, this is a little testimony to the effectiveness of cocktail parties, because last night Hunkar and I were sitting there for about an hour talking about this issue, and so this little piece about encouraging buy-in is the result of that conversation. So wherever Hunkar is he here? Yes, sir. Thanks for your help. Yeah. So we can also streamline court dockets by encouraging parties to admit or stipulate to negotiated damages estimate before trial or even before filing. So a lot of this can happen before it ever gets to court. We call this ADR, or alternative dispute resolution, and there's no reason why a lot of this stuff ever needs to be heard by a jury. It could be settled very easily by people in advance. We can focus debate on the nodes that matter most to damage estimates. So you may be interested to know that in 2013, there actually was a Bayesian network model that was introduced into evidence in federal court and was upheld as proper evidence, admissible evidence in court. And those of you who are in the biology space, you'll be gratified to know that it had to do with polar bears, right? So it can. They rejected an evidentiary challenge to a Bayesian network model that confirmed other evidence of polar bear population trends, and this was in Safari Club International v. Salazar in 2013. Bayesian reasoning also appears in the Federal Judicial Center's reference manual on scientific evidence, which notes that Bayes' rule is routine in cases involving parentage testing, and that most courts admit Bayesian probability of paternity evidence when the prior odds are disclosed to the jury. So this is a big deal in court, is the priors, right? You're supposed to walk into court as a jury member and not have any predisposition about what the outcome of the case is. Bayesian reasoning doesn't really allow us. I mean, we can have a uniform prior, but the thinking is you should have a prior. You should use those prior. Don't ignore what you already know. So it is a little bit controversial. But as long as you reveal what the priors are and you allow the jury to experiment with different priors, there should be no problem there. So thank you very much. It's been a pleasure. If you have any questions,